that in case of real property transaction in India is always a challenge for many of you. And there also it needs that one would like to see how we can have it with ease. Similarly, remittance of funds from India, that also is a challenge. And that's where also I would like to guide that how it has been made more comfortable. So with this, I will, the subject is complex and there are so many, income tax is very vast in India, but I try to focus on certain areas where I feel it may be of more importance. One area is I wanted to share the basic framework or overview of Indian taxation. I would like to run through quickly, but I look forward to take any questions also. And then other topics are estate and trust planning, taxation of real property, repatriation of assets and income, and there are quite a few people who come back to India, how they need to manage their affairs. So, overviews of Indian taxation. Now here, I will share with you framework of Indian taxation. Central tax regime, no concept of state tax in India. Financial year income is chargeable to tax, April to March, unlike calendar year here. No tax on citizenship. No concept of pass-through taxation and joint tax filings. Tax is based on residential status of a person, which is determined on number of days stay in India. And this is generally like in US, you consider last 3 years period of stay in US. But in India, it's such a complex system that even one can go back as much as 10 years to determine the residential status and maybe how to reduce your taxation in India. Highest rate of withholding taxes for non-residents at 36%, or if there is a lower rate, but which is a highest rate for capital gains and others, you have to, your withholding taxes at the highest rate. Yeah.
Sorry, when you are talking about the Indian income taxes, could you elaborate when you get to the state and trust taxes? When you talked about number of days going from 5 years, 7 year rule, and 10 year,
yeah.
Does that resonate in terms of Indian income taxes as well as estate, or are they separate for day count when it specifically comes to income tax versus estates?
No, there is common provisions for income tax, which is applicable to estate tax also. You see, in India, there are two acts which is relevant for all those who invest in India. One is the Income Tax Act, and second is Foreign Exchange Management Act, which deal with your transactions in investment, properties, setting up entities in India, etc. So many, those type of transaction, financial transaction, I believe. Yeah.
How likely and how fast India will move from fiscal to calendar year?
Well, that is what we have heard. But there are certain things where it is uncertain. So, you know, I can't comment much. Okay. So, highest rate of withholding tax for non-residents at 36%. No dividend tax on non-residents, but even for residents up to 10 lakhs of rupees dividend is not taxable. Loan or advance by closely held company having accumulated profits is taxed at 30%. There are conditions, etc. But I think there is a similar provision here, which Vinay can certainly deal. And in US also now, since the corporate rate taxation has been reduced, one may say that I will hold money in corporate and then not and pay lower tax, and then I may not distribute it as dividend, but may try to find ways and means to use those liquid funds in a company. But in India, there are very strict rules and regulations, and anyone who uses company's funds for his personal use as a shareholder or in his associate company, there is going to be a tax liability. Next is, there is a concept of clubbing of income in India. If any asset is transferred by a spouse to other spouse, or by parents to the minor children, or by or to a grandchildren, or even the daughter-in-law, whatever amounts are transferred, when any income is received by the recipient, income is required to be declared in the person who has gifted the money. And this is commonly, this is a regular provision since many years, but I find that non-residents who hold their accounts in India and husband and wife or the children, and you pass on the funds from one account to another, many times as a gift between them, and it affects it. There is a potential of some litigation in India regarding where do you offer your income. Yes.
When does the gift complete? I have given a property to my daughter, and I have filed the registration and everything else. I actually gave a gift.
Yes.
Where is the question of the income coming back?
Okay, let me explain you. Yeah, I need to explain. See, what happens that someone who has gifted liquid funds, equity shares, securities, or property, when it is transferred to the other person is likely to earn out of that. If property is given, rental income. If it is sold, capital gains, then interest income or capital gains in securities. Whatever this income is earned by the recipient who are minors or your spouse, the spouse or minor's income isn't when it is earned by them. It will be clubbed with the
minors, yes.
Yeah.
But if I gave the property to my
major
daughter,
yes,
then the dispute is complete and I'm not worried about it.
No, that's right. For major, this is not applicable. Right. Okay.
You said daughter-in-law, so nothing about son-in-law?
No, son-in-law is a dear one, you know. Generally in India. Okay. May I proceed further? Okay. Income of minor is subject to tax in parents' income, and there is exceptions in relation to artists. Say is a TV or film or any other artist, and minor is earning income on his own, maybe special skills, manual work, and differently abled. So that is physically challenged people. For these people, income of minor is taxed separately in minor's hands and not in parents' hands. Vinay, do you have to say anything on this? No. Okay. All right. Okay. Next is prescribed valuation pricing applicable to taxation of transfer of property and private equity shares in a private company. Last 5-7 years in India, there have been substantial change in the provisions on transfer of equity shares in closely held company, unlisted company, or transfer of property among non-close relative. For closely held, close relatives, gift is not a tax, transfer is not a tax. But for those who are not close relative, who are exempted category, or if there is a genuine business transaction between a company, shareholders of two companies, if the shares are not properly valued in accordance with the provisions of Act and the rules, then there is going to be attraction of tax. If you have sold it cheaper, then maybe the recipient may be taxed on income. And if you have sold it cheaper, you may have to pay tax on as a capital gain on a higher amount. Similarly for property also, that if you sell the property at a price lesser than the market value as prescribed in stamp duty or registration authority valuation, you will pay the difference as tax. Now, this is applicable even to the developers. Now, this whole concept of taking a proper pricing for property and valuation of shares is effectively for the purpose of avoiding cash or black money transaction with which we are aware. And as a matter of fact, the situation is that last 5 years, so many professionals and the businessmen are aware that these provisions have a very good impact on the declaration of proper pricing of transactions and maybe less amount of cash generation. Any question? The next is no gift tax if made to close relatives. To others, donee is taxed as income. So these are the transactions. One is to be careful. If you give to someone else who is not relative, close relative, or if you receive from someone who is not a close relative, you shall be liable to pay taxes on whatever you received under consideration or free of charge.
Can you elaborate close relatives in the law? What who are close relatives?
Yeah, close relative means husband to wife, your children, brothers, children, sisters' children, maybe grandparents, grandchildren, that way. So that details are available. That it is given in Income Tax Act, which I can share.
So here, let me make a comment here. So this is something where the U.S. and Indian law kind of differs, because in the U.S. there are no pre-described relationships, right? It's a subjective determination as to whether you're making a gift out of true generosity when met with nothing in return. You can have a situation where there's a family conflict, and a transfer between family members would be a taxable transaction, and I could give you a gift as a friend and it not be taxable, right? So sometimes this will come up with my clients that they're saying, okay, it's a gift in India, why isn't it a gift in the US? So different criteria.
Yes, we do find that there are certain difference of provisions, and
We have a maximum limit on a gift. Is there a maximum limit on a gift for years and for lifetime?
So you have two different concepts, right? In the US, I'm concerned about the US gift tax being imposed on the donor. Like in India, if it's not sheltered under as a gift, then it's income to the recipient, correct?
yes, that's right. Yes. And which I've seen, in case of transactions in NRO or NRE account, when there are transactions between two non-residents, I find that sometimes it is not within the relatives prescribed, and then it may attract tax, you see. Next is carry forward of losses allowed for 8 years in India. I think here it is allowed for all the time to come, probably. Yeah.
Depending on the type of loss.
Yeah. Okay. All right. Thank you. Income received in India by non-resident attracts income tax conditions. This is typical, may not be applicable to many, but what I have seen is that there are some people who are non-resident, and sometimes I find that they have a banking account in India, and the person may be working in US or other countries, and he may have given some services to someone outside India. He is a non-resident, and he will ask the payer for the services to remit the money to India in his banking account. Now, sometimes this bank account is not declared in the country where he is resident and is liable to pay tax. So it happens that whether he is liable to pay tax in India. So as far as Indian Income Tax Act is concerned, irrespective of what happened in his country, it is taxable in India, provided he has given service to someone and that person directly remits to his banking account in India. This is the sequence of the transaction. If it is possible that someone has rendered services in South America, the party has remitted money to his account in, say, UAE, and then subsequently if money is transferred to India, then Indian tax is not attracted because of this provision. So I explained it for the reason that this particular statement is not misunderstood. Yeah, any query? Yeah.
I have a question for this.
Yeah, please.
He said it's zero, but let's say the person is performing services in India, he is non-resident of the United States, and if we give them a remittance, what is our obligation here? We have to report that by filling out any forms, or we have to deduct tax.
So I was busy getting more wine. What was the question? What was the comment?
Because he needs that someone has performed services in India, and he should directly remit the funds to her account in India.
So in a business context,
Yeah.
what we need is the person who's making the payment to the US needs to have a GSWA form to document that it's not US sourced income. It's kind of like a W-4. It doesn't go anywhere, but you keep it in your files, and that's your proof as to why you didn't withhold US tax on that outflow and output.
Yeah.
Carry forward losses for 8 years. Is it for corporate, partnership, and individual entities all across?
For all.
All?
Yeah. That's all.
Would you comment on the PPAA? In practice, I find myself paying 60-70% taxes on income in between India and US. But I mean, this whole production about DTA stands for double taxation avoidance between India and US.
It doesn't work very well. No, if you're a US citizen, it doesn't work very well. We'll talk about that a lot as we get into some of the transactions. But India has a fundamentally different approach to taxation when it comes to things like dividends, for example. And so,
Rental income.
I'm sorry?
Rental income.
Rental income. So it doesn't work it really doesn't work that well. I agree. And that's why the planning before you do any major transactions, especially selling property, is very important so you know after the transaction how much cash you're going to end up after tax, in your pocket after Indian tax and US tax.
All right, thank you.
Get it?
Yeah. Oh, sorry.
What would be the implication in the lessons of the US if the property is located in India, give it to the Indian relative? What would be the implications for the person who received? Because in India is considered a gift for the recipient, and for the US, who are the donor, really is a gift tax for the US. So what would be the complications between the both countries? I mean, where is it double taxation?
Yeah. No, I will say that if a US person gives gift of property to a relative, if he's one of the specified exempted category relative, there is no question of tax in India. For US,
So I'll give you two different answers. One is if it's truly a gift, then you'll use your unified credit based on that amount. But if the facts are that you're making a gift of property, the relative is selling it and then giving you some cash back, the IRS will look at that as that's your sale. They've just acted as your agent, so they'll disregard the gift. Okay, so you're making a gift of property, and the person in India keeps the property or the sale and does whatever they want.
So it's only US, I guess, to report only a gift tax.
Correct.
And nothing to be reported by the recipient in India.
I believe so. No.
yeah, it depends on relative. Correct. And there should not be any counterparty transaction. You see, this had happened in the past in India.
You just explained the recipient who received the gift.
Yeah.
In India.
No, if the recipient is one of the specified relative of the donor, then there is no tax in India. But if he is not, then the recipient will have to declare its market value of the property as his income, and he will be taxed at the rate of income, which the maximum rate is about 36%. Yeah. Yeah.
Does it matter if the donor is an Indian resident or not?
Pardon?
Does it matter if the donor is an Indian resident or not?
No.
The US resident.
It doesn't matter whether is Indian resident or US resident. So long as property is in India, transaction is in India, and it will attract local provisions of taxation.
To his question, let's say the donee is a non-resident for India, and he did not fulfill the present state. Even then, he has to report that as income. He never went to India. He just have a property. He went there for 10 days, get the property transferred. Now,
Yeah.
he is non-resident for all practical purpose for the taxation. In that case, also he has to report that as income.
So I'll just repeat I'll understand the question. Someone who is non-resident, he has been given property in India by his relative. Since the property is in India and non-resident has received the property in India, so non-resident will be deemed as a person who has received something without consideration, and he will be attracting the provisions of tax in India. If it is not from a close relative in India, resident person.
But if it is from a close relative,
If it is close relative, no issue, no tax, no tax.
then on the US side,
Yeah,
there's no tax, there's required reporting of the receipt of a foreign gift.
I see. Okay.
Would it be considered foreign gift? US
question again?
If a US citizen gives a property to a US citizen.
So if a US citizen gives a gift of Indian property to another US citizen, it's a US gift. It's subject to the fact that the property is in India is irrelevant. So it's a unified credit. You're eating into your unified credit for the US donor. And the recipient doesn't have to do any reporting because it's a gift from a US person.
What about Indian?
Indian tax will be attracted if it is not among the close relatives.
But if it is among the close relatives, there's no
No, then if it is close relative, yes, totally exempted. No tax. Okay. Yeah, I think. Okay. So the basic framework of Indian taxation I've explained, but I may also, to some extent, have to take it again to explain you in little more detail. However, I felt that let me explain you briefly about what are the business entities in India. So, private limited companies, then there is branch office, license office, then partnership firm, limited liability partnership firm, and charitable trust. These are the entities. But apart from that, large corporations, that is public limited companies, are also entities in India. You may have also heard about Hindu Undivided Family. HUF is also an independent entity in India. And there is another entity, two entities, which is known as Association of Person, that people come together, and joint holders of the property. So this kind of different entities are there. But I thought that let me just explain this, that all these entities now, because of more interaction between non-residents and people in India or for businesses, lots of entities are set up. So I will quickly run through that. That compliances of yearly nature is required for all the type of entities locally, but compliances for setting up may be different. So that is very important, that one need to understand the compliances for setting up, and sometimes it take more time. And compliances for branch office and license office, it becomes very complex. You need to register your company outside India as a company in India, and lots of legal processes are there, and you need to obtain prior approval. Similarly, for partnership firm, LLP, yes, setting up takes some time, but no approval is required generally. Charitable trust is a big challenge, and it's a very complex subject. So maybe later on, I will see if there are any questions on that. Other than that, I find that timeline to set up, that is fine. I will share this, it's more of a factual information, capital requirement, and repatriation of investment. Whatever investment that you made in these entities, normally I will say that income as well as capital appreciation is being permitted for repatriation back to your home country. Okay, so now in this slide, I'm just taking up quickly taxation system comparison. I was talking to you that India is least tax nation. Let's see, in individual taxation, in India we have 36%, but in US it is 37% federal rate. Partnership firm, LLP, S-corp type companies in India is charged to tax at 35%, but US 0%. However, the individuals will pay tax in their filings at 37% approximately. Next is corporation tax, C-corp, domestic company as well as foreign company. Rate of tax in India is higher now, 29 to 35%, and for foreign company it is as much as 44%. However, recently US has reduced tax substantially to 21%. Dividend tax, there is no dividend tax in India, it's 0%. Effectively, it is the company which pays the dividend tax in India, so shareholders do lose that much tax or that much reserves. USA, what I understand, federal rate of tax is 20 to 37% on dividend. Yeah.
So let me just make a comment based on what Ram was saying about the double tax. So in India, a private limited will pay, when it pays a dividend, it pays obviously the corporate income tax in India, and then it pays a dividend distribution tax. and that dividend is tax-free in the hands of the recipient. In the US, we obviously have it the opposite way, right? So we still have the same corporate tax, but the dividend is taxable in the hands of the recipient. So you have a real problem when a US person owns a interest in an Indian private limited and they pay a dividend, because the US resident generally cannot get a credit for that dividend distribution tax. And you're paying tax as US tax when you receive the dividend. So you really have 3 layers of tax. You have the corporate tax, the Indian dividend distribution tax, and the US personal dividend tax. So it's a problem.
Yes, there is substantial multiple taxes.
What is worse is as a change in 2017 tax changes, if you accumulated your income in the company in India, you will have further problems in the US.
So that's a whole other seminar on repatriation and all those other things.
Yes, that's right. Okay. Next, capital gains, long-term. Listed securities in India, which taxes have been recently introduced. Otherwise, so far there was no tax. Now it is 12%. And other assets like property and unlisted securities, it is 12 to 24%. And here in USA, approximately 20% is the federal tax on long-term capital gains. In India, short-term listed securities on exchange is 18%. Others, it is 18 to 36%. And here in USA, it is about 37%. Gift tax, there is no tax in India among close relatives. In US, there is a 40% tax. Annual exemption is $15,000. But and inheritance tax here is in India, there is no inheritance tax, while in US, you have inheritance tax at 40% beyond 11.20 million. Vinay, you want to say anything about it? No. All right. Okay. Yeah.
In the comparison, I saw pretty much no difference between partnership firm and an LLP.
Yes.
Is there any pros and cons about which one is better over the other? Or?
In India, people prefer limited liability partnership, so that your liability is limited and there is no double taxation. Because if you set up a company, corporation, so we don't have that pass-through corporation set up in India. So people will generally go for LLP to reduce their taxation. Because otherwise, if it is corporate, then you have to pay tax on corporate income and then again on dividend.
Compared to partnership
firm, yeah.
What is the difference between partnership firm and LLP?
I will say there is no difference. There is no difference except that not from tax point of view, but partnership firm do not have limited liability, while LLP has a limited liability concept. So you are protected.
Let me comment on that. That's a big issue for a big difference for U.S. purposes, because an Indian partnership is treated as a partnership for U.S. tax purposes. An Indian LLP, because it has limited liability, is treated as a U.S. corporation.
I see.
Unless you make a check the box election. So that's getting more complex. But that difference about limited liability makes a big difference if you have U.S. resident owners of either of these two entities.
Yes, yeah. So one need to examine what is the ideal setup. That's right. Okay. Now, next is, yeah.
So if you're a U.S. owner, the question was to talk about that some more. When you're a U.S. owner of a foreign entity, you have to look and see how does the IRS treat that entity under the U.S. entity classification rules. So the U.S. would say, if I have an entity where I have somebody that has everybody has limited. If everybody has limited liability, no matter what they call it in the foreign country, the U.S. default treatment will be as a corporation.
If that entity is doing business here, then all.
Well, no. If you're a U.S. If I'm an owner of an Indian LLP, I may be just a passive investor, right? So I have to figure out, what do I own? Do I own a corporation or a partnership? So if under Indian local law, if everybody has limited liability, the U.S. tax rule will say that entity is a corporation for U.S. tax purposes. So a distribution that I get is going to be a dividend. If somebody's got unlimited liability, then it's a partnership, and it's as if I own an interest in a partnership, I pay tax on my pro rata share, and the dividend, the cash distribution is not taxable.
Unless you elect out of the.
Oh, yes, that's what I just described as the
Right.
default treatment. You can change that by filing an 8832.
You will not get foreign tax credit.
In an LLP, if it's taxed as a corporation, you would not get a foreign tax credit. And that's one of the reasons why we do a check the box election to treat it as a partnership, so that Indian tax that's paid by the Indian LLP flows through as if it were on a K1 to the US shareholder, to the US partner, I should say. So again, that's like a subject for a whole other
And
seminar.
that gets into the subject to
It's the same criteria as if it were in the US. It would be depending on whether you're passive or active.
But in other words, if in the partnership, if you are invested in partnership firm, then you are unlimitedly liable, you are generally liable.
Well, that's determined under Indian local law. And that determination drives the US tax treatment.
Here, non-participating partner, investment partner is equal limited partner, and one is the general partner.
So,
How do you elect out of?
You would elect out by filing an 8832, a check the box election.
I see. Move forward. Thank you. Right. So, in this slide, I'm sharing scope of total income in India. In India, we go with whether the person is resident in India or non-resident in India. These are the two concepts. This is based on number of days stay in India. So, if someone is non-resident in India, whatever income that he earns in India is only taxable. That's all. If he is earning any income outside India, irrespective of its citizenship or whatever way, or OCI card, he is not taxed on income, such income in India. And person who is resident in India, he is taxed on worldwide income. Wherever he earns, from wherever source he earns outside India, he is liable to tax on world income. Now, in India, there has been third concept, which I feel it may not be here. There is a third concept which has been provided under the Income Tax Act for the purpose of people who are visiting or coming back to India, and they intend to start up and get set in India. And for a period of 2 years, generally, they are granted tax exemption in respect of their income outside India. This is what is the concept, and this concept has been converted into a particular number of days in the past, in the current year. And if a person is able to establish that on the basis of number of days in the past, whether he is resident but not ordinarily resident, as is given in point 3. In such a case, his income outside India will not be taxable, which is in the nature of capital gain, etc. I'll just give an example. Someone who comes back to India, he will continue to hold his assets outside. Or some expatriates who comes to India, he may have his assets in India, income, etc. So for a period of 2 years, your income outside India is not taxed in India, even if you are in India for almost 365 days. This period of 2 years, generally as a professional, it is possible to work out number of days guidance to our clients, and it is possible to get it extended from 2 years to 3 years or 4 years, or sometimes 5 years also, depending on number of days that he visits outside India for next 2, 3, 4, 5 years. So basically, anyone who is non-resident, he should ensure that he continues to be non-resident in India, and then he is not liable to tax in India in respect of his other income. Only Indian income is taxed. And sometimes whenever Indian income is taxed, we did discuss that if you are liable to pay tax in the country of your residence, where you are resident and paying tax, there is a potential of obtaining tax credit. But as we know, there are certain limitations. Yeah.
Suppose if a person moves back during those 2 years, moves back out of the US, out of India,
Yeah.
and then again moves back to India, so will he still get the exemption again for the next coming 2 years?
If he moves out of India, then what happens? For 2 years he was resident but not ordinarily resident. But the moment he moves out of India, he will come under the category of first. He becomes a non-resident. And the moment you are non-resident, there is no question of paying tax in India in respect of your foreign income. So you even need not depend on this third option.
Don't they track over a 7-year period? If you keep coming back 7 to 10 year old, would that kick in? That idea, as he's saying, if somebody came back over.
Yeah. So what has happened? Let me explain it now, although it is taken up later on, but at that time I will not take it up. In India, what happens that number one is that for 2-year period, but number of days are 365 plus 60 days or plus 183 days. There is another provision which says that if you are not in India, if you are in India for less than 729 days in past 7 years, up to 7 years, then again you will be considered a not ordinarily resident, so 729 days is a long period. You can be in India, you are non-resident, you come back to India after a long time, and you can be out in India for almost 120 days for 6 years, and still you will be not ordinarily resident and not paying worldwide income tax, tax on worldwide income in India. This is how you can protect yourself. Okay, so here I've taken this basic conditions for residential status. This is complex, but I'll just run through quickly. If you are in India for 182 days or more, you become resident in India. So any non-resident should try to avoid being in India for more than 182 days. And if you are in India for more than 182 days, sometimes that 729 days rule also may help you to escape becoming resident. And you may avoid taxation of foreign income in India. Now, I think this is complex, and I would like to skip it because if I explain, it's going to take more time. You see, but as I explained you earlier, there are people who live for India, and someone leaves India, say in the month of October. So if he lives in October, it happens that he's settled in USA now. From October to March, his stay in India is less than 182 days. And if a person lives like this, then he becomes non-resident and is not liable to pay tax on his income outside India in that particular year. But if someone lives, say June, July, etc., then someone lives someone leaves after September, then he will be in India for more than 182 days. So he will attract tax of his foreign income. And if he leaves before 30th September, then he will continue to be non-resident because he was in India for less than 182 days. For example, someone lives in January. So he was in India for 9 months, so more than 183 days. So any income earned by him from January, February, March in US or other country, he will have to pay tax in India in respect of those 3 months. Yeah. Yes, but you need to establish that you are resident in both the countries. The moment you are resident in both the countries, then double taxation treaty will apply.
So your 182 days count is based on the fiscal March.
Yes.
Not calendar.
Not calendar. And any number of days. But there are certain issues. If you come to India at about 11:30 at night, so you were only for half an hour on that day, but it is considered that yes, you are in India for that day. Similarly, if you leave, yes, yeah, there have been some judicial decisions in favor, but I will not advise anyone to take chances on that. You see, yeah, and it is important for you that you keep the record of your passport, which shows the date to satisfy the tax officer in India. That may be very important. Okay, so the next is corporate taxation. I've just taken one simple example of, there are US companies which charges or invoices Indian companies for fees for technical services or royalties. Whatever this invoice is raised on Indian companies, the normal rate of taxation is 11%. Now, this tax is in respect of income of US company in India because of the deeming provision that they have rendered the service even if it is outside India. The tax department of provision says that whatever these fees are there, you will have to pay tax in India 11%. Now, normally, Indian companies will tell foreign companies that whatever the tax liability is there in respect of this, we will pay. So normally this 11% is paid by Indian companies, you see. So these are the provisions. However, there is one new tax, as you may be aware, goods and service tax has been introduced in India. And whenever US or any other company raises invoice on Indian companies, there is a liability of goods and service tax. And again, foreign companies are not required to pay these or obtain registration in India in respect of GST. So normally, whatever the invoice is raised, say US dollar 50,000, GST is 9,000, amount to be paid to foreign companies 50,000, and amount to be paid to Indian government towards GST is 9,000. This 9,000 is being paid on the reverse charge mechanism by Indian company to government authorities. You know, this is how this liability is. This is for the sake of information that whenever any US company raises invoice on Indian companies, their cost goes up by so much of amount. Capital gains on listed securities, I will run through quickly on this. As you may have, in my slide, I had explained that in the past, there was no tax on listed securities sale of shares, which is long-term capital gains. But from this budget, there is 10% tax introduced in respect of sale of shares of listed securities as well as listed mutual funds. So what the government has done, they wanted to keep this tax at a mild rate or very nominal amount, and government decided that any gain or appreciation in listed securities up to 31st January 2018, whatever the appreciation is there, that appreciation will not be taxable. So anyone who is holding shares in so many years and a appreciation is there as on 31st January 18, in example, he has bought the shares at 50 rupees, market value as on 31st January is 18, is 100 rupees. This 50 rupees is generally considered as not taxable. If there is any appreciation beyond 100, then that much amount of gain is considered as liable to tax at 10%. So you may pay 1 rupee. Otherwise, you had total gain of 50 plus 60, so 110. You are not liable to pay tax on this.
So there is no long-term and short-term provision?
This is applicable only for long term. For short term, no such higher value is to be taken. Short term is less than a year. Yeah, so that benefit is not granted. Again, this is overview of Indian taxation. Like worldwide, there are a lot of changes in taxation provisions, which are for efficient tax collection and compliance and avoidance of taxation, you know. So these are the concept in India also. Place of effective management of a company. This is for the purpose of taxing foreign companies which are managed from India. That is number one. Foreign companies will be treated as taxable in India if they come under the definition of place of effective management of that company is in India. Next is GAAP, generally accepted accounting regulations for overriding provisions of the Act or double taxation treaty. Transfer pricing provisions are for international transaction between associated entities, and provisions on safe harbor rules, thin capitalization, etc. Here I will share only one example. We have some company, a software company, which has set up a company in India, and it provides services to its parent company or other companies in US. So whatever this transaction is done at a price, the charges or software development or other services are charged at a particular rate. in India, they try to examine, are you charging fairly for your services or not, and whether any revision is required. Recently, the government has changed that for such software companies, if you show a profit of 18 to 20% on your invoice that you have raised on US companies, we will accept that as final and will not let you take into litigation. So this is a provision which is for facilitating or reducing the litigation and making things clear. However, all these provisions which are for safe harbor rules and for avoidance or evasion of taxation, you must have heard about a recent transaction which is still going on. Walmart Inc. has taken over Flipkart in India. Now, I will go from the last part. The last part is Flipkart Private Limited is a company in India which is being controlled by Flipkart Pte Limited, that is a Singapore company. And this Singapore company's equity shares have been taken over by Walmart. The shareholders are Vision Fund, SoftBank, Tiger Investment Mauritius, and others. So there is no transaction of transfer of shares in India. There is a transfer of shares of Flipkart Pte Limited, and no shares in Indian company have been transferred. Now, last 5 years, before 5 years, government has introduced a provision wherein it says that if a Flipkart Pte Limited's shareholders, these 3 companies, transfer their shares and the substantial value of Flipkart Pte Limited is coming from Indian entity, then this transfer of shares by these 3 entities to Walmart will attract taxation. There are various rules, regulations. Exactly similar thing had happened for Vodafone, if many of you may have heard about that, and more than $2 billion taxes have been raised against them. At that time, there was no provision of attracting tax. But afterwards, the changes have been made, and there I read in newspaper, because I was here, that tax department has sent notices to the transfer of shares that you may be liable to pay tax under the amended provision. Now, this provision fundamental is only one, that Flipkart Pte Limited shares are outside India. So far, in Income Tax Act, there was no provision that Flipkart Pte Limited shares are outside India, so you can't touch them for income tax purposes in India. Now they've changed that in the event that Indian company Flipkart, whose value is controlled by a foreign company, and foreign company controls more than 50% of its value through its shareholding, the shares of Singapore company will be considered as a share in India. Citus is in India, and because of that, these provisions, yes, the international transactions in respect of such transfers will attract income tax. I thought, let me just share this with you. Vinay, how much time is there? We need to move faster. Yeah, estate plan, it's better. So if time permits, we'll come back. Otherwise, let's move forward. Now I will come back to the topics of estate planning and real property, etc. What I find is that, having attended non-residents since so many years, I find that NRI's expectations are their economic interest, real estate and investments, and they visit for the purpose of tourism and for charitable contribution. But the way these issues are to be attended in India, there is a disconnect. The way you can attend in US, you are used to those kind of arrangements, systems, processes. But in India, it's very tough or complex. So what you need hassle-free, timely compliances for all these 4 things in India, protecting and passing on the assets, continued personal bonding. When you come to India, don't waste your time with bankers or RBI or tax department. Enjoy your time with your friends and relatives and travel. Next is charitable contribution also should be made easy. So I go to next, how to work this out. So first I've taken up estate and trust planning of assets. The present status of assets in India of non-resident is there is real property and there are other assets. These are held by US persons as well as maybe the parents of US persons are holding these assets. Fortunately, all those who are holding property or investments in India, substantial appreciation is there. It makes a lot of money for non-residents to receive that from their as a legal heirs, you know. So it is important that how do you plan this better. So next is how to transfer to next generation. Currently, you cannot visit often. Your children have no time or interest. Legal processes are complex and time consuming. Local person competency or reliability is not there. So how to transfer? There are two options generally, and one is will that you transfer to your next generation, and second is the trust. Now, I briefly explain law of inheritance. If there is a will prepared by anyone, one has to follow the will provision and distribute, or legal heirs will take the property or assets accordingly. If there is no will, yeah.
When you say a will the Indian authorities recognize the US will, or do you need to have an Indian will also?
Yeah, that's a good question. I'll come for that, but let me explain it right now. You see what happens that a person may be holding assets in different countries. And for each country, he needs to provide by a will, if he goes for will, to see that estate is passed to the next generation. What happens that it is possible for you to make one will in US in respect of your assets in US or India or other country. And that will be valid in India also. However, it will be uncomfortable for someone that you have 3 assets in India and 10 assets in US. If you make one will and go to the court of law, then court of law in India will say, what about 7? Has it been completed, not completed? How they look to these 3 assets in India. So I generally guide people that you make will for each country, and that will be much more comfortable and safer. Okay. So if there is no will, then the assets of Mr. A, US $12 million, legal heirs are wife, son, daughter, and mother. So all will get this money equally. Here what happens that it is A's property, but share goes to mother who is alive. Now, normally it may be possible that Mr. A may feel that I need to ensure that property and my assets goes to my family and not to my mother, because generally mother is taken care of. But if a will is not prepared, then mother will have a right for $3 million. That is also fine if he's the only sibling. But if he has brother or sisters, then if mother gets $3 million, brothers and sisters of A can claim rights in mother's assets, and accordingly it is important that one has to make will ensuring that it is properly taken care of his family members first and then others. So this is one. Okay. Similarly for HUF assets, co-partners have the right, father, mother, son, daughter, all those, and they get it equally. Only one thing is there, that in both these cases, if you find that Mr. A had a son who is no more, and son's family is there, then son's family members will have a right. If son is no more, son's family will have a family member, his children, his wife will have a right equal to his share, whatever his share was. However, if mother is no more and mother has a share of $3 million, 1/4, if mother is no more, then there is no question of giving anything to the mother, so that there is no question of going to any other sibling. This is the basic provision. It's quite complex. So many issues are there, but basic, fundamentally, these are the provisions. Any question? Yeah.
Is it automatically equal to all the beneficiaries or how in India?
Yeah. See, they have defined the legal heirs. So class 1, class 2, like that. So first in class 1 and 2, wife, son, daughter, and mother come. So if these people are there, then essentially it will go to them. Even in this category, if only one person is there, then it will go to son. Say he was the only person, it will go to son. But if these people are not there, then the cousins and these and that other people will come into picture in accordance with the Indian Succession Act and Hindu Succession Act's schedule in which they have given guidance. Yeah. Pardon?
Would there be a difference if the daughter is married?
No. Married daughter also gets. Not only in individual property of A, but even in HUF property also married daughters. If,
The daughter is married.
yes,
Or
her children can claim, yeah.
Now, you said mother is dead. There is no further issue, but if mother died, but she was remarried, then what's the issue?
Who was remarried? Father is remarried.
No, mother.
No, mother died.
If mother died, but mother was remarried,
Okay, okay.
then it gets, then the husband was the new,
No,
no?
no, husband will not. Yeah, yeah, because if she, no more, yeah.
Automatically,
Once you remarry, she goes out.
One more, yeah. Excuse me.
if she's alive, even if she remarried, she gets the son's share. But if she's no longer alive,
Then her new husband will not.
Yeah, right.
That's the question.
But
Yeah.
without will, if it's actually of property, automatically the eldest male member will not become a karta and still will be an actual.
Yes. So whenever there is a co-partner not available, so next co-partner will take care of, he will become karta. But karta does not have extra right, extra share. Yeah, it has to go in accordance with the.
There is no requirement to divide the property under the family dispute.
Ah.
The state can be carried on as actually a property.
Yeah, HUF can continue. That's right. Yeah. Okay. Next.
daughter is abusive.
But that cannot be massive. That creates lots of problems. Let's not go there.
Yeah. Yes. Yeah. Okay. Should I move? Okay. Now, how?
Very quickly. Can karta be the US person? No. I don't think so.
According to me, karta can be US person. Why? Why? Because you are a member of HUF. Wherever you are located, you can be karta. Yeah.
I thought there was a restriction.
No, no restrictions. Yeah.
There was no will, no property was distributed to the daughter. Is there a statute of limitation in which the daughter can claim, or?
Yes, but that limitations is for a long period. But exit limitation, whether it is 10 years or 20 years, I don't know. You see, but it's possible that something is not given to daughter, and later on, if everybody agrees, then it will be accepted as a genuine distribution as per her rights. But if there is a challenge, and then period of limitation is something which can prohibit the daughter to take any money out of it from the others. You see. So going forward, estate planning. Parents in India and own assets in India. This is a typical situation. How one would like to do, whenever I consider to advise anyone for estate planning, I will say that it's your money, and ensure that you continue to control till you are competent, you are alive, and you need to use it for your own purpose. So I say that what can be the objectives? It should be, you should continue to manage even after it has been properly planned. Revise the distribution, that you can change it. Can you take it back for own use? Yes, you should have this kind of planning where you can take it back also. No legal process to transfer to legal heirs. This is very important. Indian parents, and they are holding assets. Normally, if you go through the process of court and other thing, it takes 3 years or more. Disputes and also processes, legal processes where all non-residents also have to come together. So it's a big hassle. Is it possible for someone to cut down in some manner? So there is an option, no legal process, that is trust, which we will deal. But where it does not require any legal process, the moment the settler is no more, the funds can be encashed and money can be transferred by the trustee of the trust. This should be the objective. Least US taxation, current and future. Indian taxation should be minimum. There should not be litigation. Under the will, there are issues, but in case of a trust, it is possible to avoid the litigation altogether. And cost and process and administration. And it should go to next generation in US. So I will explain it later. So I'll go next. Will, process and key features. Anyone can make a will. It needs to be just put on a paper, duly signed by the person who makes the will, and 2 witnesses. Will is not required to be registered. You're not required to register the will. Prepare it properly, put the name of the executor, state the list or distribution of beneficiary, guidelines on investments, etc. And the will is operational, will is acceptable. However, many times we find that one will and next will and next will and next will, then there are issues and problems. So sometimes people ask whether the will can be registered. Yes, will can be registered. But having registered the will, subsequently you can have one more will which will be registered, or you can have a subsequent will which will not be registered. So between the two, a registered will and subsequent will which is not registered, even non-registered will have a precedence because it is done later on. You know, there is no validity of a registered will if there are subsequent will. Now, it is important that there are witnesses properly stated in that. There is no stamp duty on will registration or otherwise, or whatever, no stamp duty on will. And I explained you, will should be there for each country's assets separately. However, if there is a will and if there is an immobile property or held by the testator, then a probate is a must in respect of immobile property. So one will have to apply for probate in respect of all the assets. You can't restrict it to immobile property only. If the executor is not appointed, then one is required to obtain letter of administration, wherein you go to the court and ask that you appoint an executor. Court will appoint an executor. And succession certificate is obtained where there is no probate, and where letter of administration is not obtained, succession certificate is asked for from the court. So,
One question, witnesses, do you recommend family members or non-family?
One will prefer non-family members, preferably say doctor, your family doctor is good, and maybe an attorney also, or chartered accountant, generally stick. Generally avoid executors, witness, you know, it's good, yeah. And no beneficiary, it's good if beneficiaries are not the witness. Okay, so going forward, trust process in key features. A settler creates the trust. He will contribute the assets to the trust. Even third party can contribute assets to the trust. There has to be trust deed. And in trust deed, there is going to be a trustee, settler, and beneficiary. Beneficiary have rights as per the provisions of trust deed, but there is Indian Trust Act which also empowers beneficiary to enforce his rights against the trustee, or if settler is a trustee, against the settler also. So trustee has to act in accordance with the provisions of terms of trust deed. and in accordance with the Indian Trust Act. Now, there are concept of protector and advisory board. These are additional features to if there is large wealth and someone wants to take care and support of additional people, professionals who may be useful. But I think because of time, I cannot deal with that, and I would like to skip.
One question for me. If the Indian trust have the US beneficiaries, are they required to file the US trust?
Yeah, so we're going to talk about that. Okay,
yeah. Okay. So, timeline for a private trust. Yeah.
When were you funding the asset into the trust? Is there any stamp duty tax or anything?
Yes. Yes. Okay. Yeah. Which I'll explain afterwards. Yeah. So, timeline for a private trust continuity. In India, private trust can be established for the life of beneficiary. So, A has his son, he can establish trust for his son till his life. And the extension of trust is for unborn son of the presently existing beneficiary and till he reaches the age of 18. So someone is there alive now, his entire life trust will continue, and further, if it is stated that his future son, the son has to receive it by the age of 18. That is the maximum extension of a private trust in India.
Not the female child.
Anyone.
Okay.
No
So
issue.
when you say
Right.
son,
Yeah. No. Okay. Any legal. That's right. Okay. So I'll go to estate planning by way of a trust. You see, in India there are 3 types of trust: revocable trust, specific trust, and discretionary trust. In case of a revocable trust, the person who settles the trust, he will have power to take back, change the beneficiary, take back the assets, he can undo the trust and do whatever he wants. So this type of trusts are more popular because anyone who creates such trust, he knows that he can take it back, he can change, he can use the money for his own purposes. So revocable trust is more beneficial for the settler who can ensure his safety about his requirements of funds. Specific trust and discretionary trust. In case of a revocable trust, the settler himself is beneficiary. He creates the trust and he says, I am the first beneficiary, I will use entire income, asset, etc. However, he mentions that my children are also, my wife is also beneficiary. But when I am no more, when I'm no more, whatever the beneficiary is there, they will get their rights. That who will get the rights. Okay. So in case of revocable trust, it is effective in favor of beneficiary only when the settler is no more and terms of trust will apply. Yeah.
Beneficiary. Like who could be a beneficiary? The third party can be beneficiary or not?
As far as beneficiary is concerned, there is no limitations on appointing anyone as beneficiary, but I shared with you the provisions that in the event that beneficiary is not a close relative exempted category, then to that extent there is a potential of tax on recipient.
Because in gift tax, you have tax income to donee, right?
Yeah.
For the third party.
Yes.
So I'm just thinking if you can go through the trust.
No, not now. In fact, for 5 years, people tried to say that if I give gift to an unknown person or friend, there is gift tax or recipient pays the tax. If you create a trust, one will say that I've given it to a trust and then things will not be covered. But now it is provided by amendment, and even if a trust is created, you are liable. Vinay, now I have a lot of slides to go. What is your advice or guidance? Oh, sure. It shall be my pleasure to share these slides.
PowerPoint be available? Yes. So Karen is going over your house to email to everybody.
Yeah. So that, yes, certainly. Yeah. So we will.
Shrikant, I think he has a relevant comment.
Pardon?
Shrikant, yes.
Yeah.
Are US trusts recognized as an Indian tax firm, or how are the US trusts?
No, sorry.
Trusts formed in the United States.
Yeah.
Are they recognized in India?
You see, a trust established in India, US, can be recognized in India. However, you cannot transfer any Indian assets to a trust in US. You see, there are limitations under Foreign Exchange Management Act, and I can later on explain you why it is logically correct for Indian government to have such laws. You see, so I will deal little later. Okay, thank you. So in case of specific trust, a person transfer the assets and it goes to A and B. The person who has transferred the asset to the trust has no power to take it back. Similarly, for discretionary trust, again, you transfer the assets, no power to take it back. However, discretion to trustee or settler to change the shares of beneficiary, that is the discretionary trust. Yes, you have to say anything?
No, I was just going to spend a few minutes talking about how the US looks at this.
Yeah, okay.
It's very complicated.
Hmm.
So, in the US, we have grantor trust and non-grantor trust. So, if the trust in India is considered a grantor trust, if you were to pick up and move that trust in the US, and the grantor is a person that's got no connection to the US, then there's no issue. Where it gets difficult is if I have a trust that's a non-grantor trust, that the beneficiary is a US person, right? So then we get into some very complicated rules known as the throwback rules, which are rules that you really try to have to avoid. And what the issue is that we know that in the US, if you have a non-grantor trust, when the trust has income, somebody's paying the tax. It's either the trust or it's the beneficiary, depending on what the distributions are. If you have a foreign trust with a US beneficiary, if there's no distributions made, then the US has no right to tax that foreign trust, so there's no trust. But when there's a distribution, what the throwback rules say is that you have to look at the cumulative life of the trust and look at the cumulative income, not just the income in that year. And that cumulative income is income to the US beneficiary. And also, you have to look at the years in which the US beneficiary had an interest in that trust. And effectively, that income that you receive in that 1 year is allocated evenly as if it was earned throughout every year that the US beneficiary had an interest in the trust. And there's an interest charge tax for that hypothetical look back. That's what we call the throwback rules. So what happens is if you get into a subject or area where these throwback rules apply, when the US person gets a distribution, the US tax burden is enormous. So one of the main goals of cross-border estate planning is to avoid the throwback rules so that you're not trying to defer US income, or you're not trying to defer income that's eligible to a US beneficiary. So everything Kirit is talking about is great when it applies to an Indian grantor. But the minute that the Indian grantor passes away and the assets are there for the benefit of the US beneficiary, to avoid the throwback rules, you have to be able to make current income distributions to avoid these rules. Otherwise, you end up in a bad place. And I'm not aware of an easy solution. So many clients come to us and say, okay, I'm going to put my money in a Singapore trust and not have it subject to US tax for the benefit of my kids. But at some point, it's really going to go back to Hong Kong. So,
Correct.
The US allow, even though there is no distribution, you pick up the income in the year.
Yeah, I don't think so. There's no concept like that to basically.
So you have to force the distribution.
You have to force the distribution, which may or may not be possible based on the restrictions are in India.
Correct.
But can you make a trust where
Well, yeah, so if you make it a simple
beneficiary
trust, if you're
keeps
passing
in
up the income.
and the
then
distribution
yes.
is done from that part? Can you write a trust like that?
Yeah, see, in trust deed, you can always write that beneficiary will take it subsequently. But what is important, what I understand from Vinay's explanation, I find that if someone is resident in India, no US connection, no green card or citizen, and that person is alive and he's settling a trust, say revocable trust. The beneficiary will not get right. US beneficiary will not get right till that person is surviving. So all entire income for all these years will belong to an Indian person and not to US beneficiary. In such circumstances, maybe
I think that's okay.
that's okay. That's right. And it may be possible that someone creates a irrevocable trust in India. Parents are there, they are alive. They create a trust and they themselves also don't take any distribution for say 10 years. Still, maybe US tax may not be attracted because US beneficiary never had any interest in those 10 years as a beneficiary. But maybe it's a...
It could be. I was about to say, these rules are incredibly complicated. I'm not
I see.
the expert in them.
Yeah.
But it's
All right.
something else to be very careful. John?
Yeah.
Whole enterprise is art about simplifying getting inheritance from parents, particularly in cities like Chennai, Hyderabad, you name it. Properties are appreciating, but income distribution. The whole idea is to actually get the property properly settled and bring the money to the proper heirs. That's the whole production. My question is, if, let us imagine that you have 100 acres of land outside Hyderabad airport, which is now about $20-30 million. Now, my friend Vinay, when Kirit says that we're going to put this into a trust. When the parents pass away, can I settle that property inside that trust? It's a revocable trust while they're alive, but it becomes a testamentary trust because he died. Can that estate sell the property and declare it as an inheritance? Because if the property is distributed to the children, it's a murder. Because you have to pay the federal tax, you pay the state tax, and everything else. Because 2007 up to 2017, I was very comfortable. The 2017 tax law blew the lid off the whole enterprise. Would you please comment if this whole thing, can it be done in such a way that it can be distributed?
So I'm not sure I'm answering your question, but the key is in the fact you described is the valuable appreciated real estate. When it's going to be inherited, it's going to ultimately end up in the hands of the U.S. beneficiary. The most important thing is the step-up in basis. So that if the kids want to sell the land, they can do it without having any U.S. income tax, right? So generally speaking, if it's in a trust, which is the equivalent of a grantor trust, so that it would have been included in the estate of the decedent if they were a U.S. person,
Yeah.
right? And then upon their death, it comes to the kids outright, then you should get a step-up in basis, right? So that's going to be the planning goal, to make sure that...
Are you distributing the land, or are you distributing the sale proceeds? Because there are two animals.
You're distributing the land. So from my point of view, I don't care if I distribute the land and the kids sell the land because they get a step-up in basis, or the trustee sells the land and distributes the cash to the kids because there's still going to be a step-up in basis.
Why I struggle with this is because in India, they have this inflation adjustment,
Right, which
is very valuable. I don't want to surrender that. That's the important thing, that if the property is sold by the state, then I can claim all the the inflation adjustment and everything else. Perhaps because I've seen cases which are disaster. They convince a mother to distribute the land to the children before she died.
Right, so then you have a gift for U.S. purposes, which is a disaster because now the kids who have an interest of the land while the parents are alive have a carryover basis. So it's the cost basis, and obviously in the U.S. we don't have any concept of an index basis. So that's the one thing you want to avoid. And I know in India the mentality is that parents will want to settle their affairs before they die, and they will give the kids gifts. And I've had clients where they will find out after the parents died that while the parents were alive, they deeded the gift, the land to the kids, and the kids don't even know this. And it creates a disastrous situation.
This is the reason for U.S.-India tax planning is so critical. I've actually seen the disaster case happen in my
So am I.
Yes.
So when you say equivalent, would the US accept the revocable trust in India close to the grantor trust?
Well, the US, because from a US point of view, you're trying to argue step-up basis.
Correct.
So you're trying to argue that well, you're trying to argue that it's a grantor trust and the asset would have been included in the estate of the decedent if they were in the US, right? So you're going to look at the terms of the trust to see, is it revocable? And if it's revocable, it would probably be included as a grantor trust and therefore included in the estate, and therefore you should get the step-up basis.
This may help the issue that is raised by Ram. That's right. Okay. Yeah. Okay. So this is types of trust and taxability. Almost all trust, whether it's revocable or irrevocable or discretionary, all trusts are charged to tax at 36% in India generally. Generally. So I would like to go to the next slide. Taxation on income of a revocable trust. Probably I'm taking the example which Mr. Ram, you have explained. So what I say that there is a parents in India, they are holding assets. They are become the settler. Beneficiaries are US persons. On death of parents, a trust is created which is a revocable trust. Indian trustee, US trustee also. Now in such a case, let us see what happens on taxation of this trust in India and in US. So as far as Indian tax is concerned, these are the taxation, which is whatever the Indian tax is there is payable by a person who holds assets in India. So if you get dividend, you don't pay tax, and short-term, long-term capital gain, and with this in the inflation index adjustment also, your tax rate can be lower. So let's go to the taxation of a revocable trust. Same trust, US tax implications. So in this case, till parents are alive and they are resident in India, no green card, no citizenship. So what happens that tax on settler in US, no tax on settler because he is not a US person. Tax on US beneficiary, nil till the parents are alive because beneficiary has no right or interest to take any money. On death of parents, trust continuing, the beneficiary is US person, income is taxable. On distribution by trust to US beneficiary, income is taxable. Here I will take further that in such a case, if that property which is sold by the trust or US beneficiary, one is that there is a tax payable in India and you get the indexation and other benefits. So in tax in India is reduced. And as far as tax in US is concerned, as Vinay has explained that yes, there is a potential of showing step-up cost in case of a revocable trust by such a person. Okay, so this is what was...
Why even to get into the business, sell the property in the estate and distribute the money as a distribution inheritance and close the whole US chapter?
Okay, so that's what I mentioned on number 2. On distribution by trust to US beneficiary. Have I attended your point at on death of parents, trust continuing or trust not continuing? Number 2 is on distribution by trust to US beneficiary. Income is taxable in India and income in US will not be taxable provided it is equivalent to step-up cost and you are eligible to get the benefit of step-up cost in case of a revocable trust. However, the other option is that there are assets in India of US persons. US persons are holding assets in India. He creates a trust for the beneficiary who are US beneficiaries. So, settler as well as beneficiary, both of them are US persons. So in such a case, these people will pay tax in India because assets and income are in India. They will pay taxation of trust in India. However, as far as US taxation is concerned, since the parents are US persons, the settler of the trust will be liable to pay taxation in US. And on the death of parents, trust continuing, the US beneficiaries who are legal heirs will pay tax in US, as well as on distribution by trust to US beneficiary, income is taxable. And yes, if you can throw some light on step-up cost.
I mean, the fundamental assumption here is that these trusts are going to be considered simple trusts,
Yeah.
meaning they're always paying out their income currently and
Yes.
avoiding the throwback rules. And what we've not talked about here is we've talked about the taxation. The reporting is very heavy, right? So you have two main forms, the form 3520 and the 3520A. So
Yes.
even if the income is not taxable, there's quite a bit of reporting that goes along with these arrangements.
I see. Reporting by trustees as well as beneficiaries. All right. Okay.
India taxes in the trust, there is 36% tax if the trust is generating an income on the assets.
Yes.
What happens if they distribute that income? There is a tax also or no? It's tax rate.
There is the credit available to the beneficiary in US. That's what you said.
No, I'm not talking about US. I'm talking about completely
India. Okay. So in
What
India,
is the taxation?
yeah. So in India, what happens if a trust earns income, trust will pay taxation. Once having paid tax by the trust, beneficiaries are not liable to pay any tax in India. Correct. Yeah, that's right. And at this point, since this question is raised, I was thinking that if you can throw some light on trust paying tax in India, where beneficiaries are US persons and they are liable to pay tax in India via trust, whether that credit will be available to US person.
So that's exactly what I was thinking about when you were talking about that. I don't know the answer.
Okay.
The issue is going to be you have the Indian
Yes.
tax being paid by the trust,
Yeah.
and you have the US tax being paid by the US beneficiary because it's being distributed.
I
So you have two different taxpayers. So my assumption is going to be there's going to be no foreign tax credit.
I see.
Kind of like a dividend distribution tax. But I've not looked at that issue.
One thing is for sure is that US beneficiary will end up paying the tax to the north. The income is when the is reported, you better report that income in the US, otherwise you may violate the accumulation laws. So you are paying the US taxes anyway, and may or may not get a credit for the taxes paid in India.
Correct. The best case answer is that you get a foreign tax credit. And I don't know if you will.
That's right. Or maybe one would like to distribute the assets as you were telling. So sooner than later. Yeah. Okay. Now, I will come to my original subject. My objective of explaining the estate planning was that you have two options. One is revocable trust and one is will. What is better, and this comparison I have given in this is applicable generally in the case of revocable trust where parents are in India and resident in India or otherwise. So as far as litigation is concerned, in revocable trust, generally there is no question of litigation. Trust deed is submitted to tax department, to the bankers, etc. There is no question of any uncertainty or claims by beneficiaries or non-beneficiaries against the trustees of the trust, while will is always prone to litigation. That is one. In case of revocable trust or other trust, there is no question of obtaining probate, letter of administration or succession certificate from court of law for a trust. In case of will, yes, you are required to do. Not only that, it takes time, but in case of will, so many legal heirs will have to come together, apply to the court, either personally or via power of attorney given to someone in India, and obtain the probate or administration letter. So it is good between the two that revocable trust is better. Step up cost for US capital gains tax that we have discussed. I believe if it is properly represented and planned and drafted, a revocable trust may help, subject to confirmation by Vinay. Taxation on beneficiary, which we have already discussed, that in case of revocable trust, taxation on beneficiary till the parents are alive. Yes, there is Indian taxation, and later on US beneficiary. Will also is the same. Flexibility, yes, if you have a revocable trust, you have all the flexibility, and that should always be the objective, which is achieved by a revocable trust. Investment options, in case of a trust in India, has some limited options of investing even outside India. In India, you can invest outside India also. To some extent, we'll have to come around with option of 250,000 US dollars for the purpose of investment. There is no question, the person is individual, he can invest within the framework of Indian laws for anywhere, any market outside India also. In case of revocable trust, yes, trustee requirements is there. You need to have a good trustee who manages it efficiently, reliable, and do not manipulate. This may be a challenge, but in India, there are bankers who provide trusteeship services, or there are trusteeship companies also, wherein fairly, I am of the view that my experience says that they do a good job generally. And in will, you need the executor, and executor need to go through all the processes of obtaining probate and completing the distribution. Cost and administration, this is something important. When someone wants to create revocable trust, he has to transfer the movable assets, securities, etc., and property to the trust. In India, if you transfer real property to a trust, the stamp duty is attracted probably at about 5% in most of the states. And if you are transferring securities to a trust, stamp duty at the rate of 3% is chargeable. But generally, what one need to do, say you have $1 million movable property to be transferred to the trust, you can first transfer $10,000 worth of movable property securities into the trust and create a trust deed. On that trust deed, you will pay 3% on 10,000 US dollars. And subsequently, if you transfer 9,90,000 US dollar to the trust, just by means of a transfer, you are not required to pay stamp duty on that. Yes.
One quick question. For a revocable trust, the parents set up the revocable trust.
Yeah.
Basically, they have a full ownership of the trust asset.
Yes.
Why should there be a fee to transfer the assets? If I own the assets as
Yes.
grantor and trustee,
Yes.
transfer into my own trust.
Yeah.
I have the ownership. Why should there be stamp duty?
Yeah. So practically, what has happened? I've gone one step further in this. Say I created trust, and I am the trustee. So I am the owner of the property, real property. I am the settler, and I am the trustee. So even I need not transfer the property to any other person. If settler and trustee are different, then you need to transfer. In the past, about 8 years before, I represented to the stamp duty registration office, and in 2 of my cases, they accepted that, okay, no stamp duty. But last 4 or 5 years, they've changed their view. So, I mean, there is no legal challenge or result so far. So I will advise that, yes, stamp duty is payable for the time being. Yeah.
Here, that's not the case here.
That's not the, yeah, it should be, because there is no transfer, there is no effective transfer of property. Stamp duty is on transfer. You see, legally it does sound, but yes. Yeah.
The biggest benefit that need to be mentioned here is a lot of NRIs, particularly US citizens, were prohibited from buying agricultural land in India. And so a lot of people send money to their parents, and the lands are registered to their parents. I can only refer to state of Andhra Pradesh, where I come from.
Yeah.
And now the parents are aging, and there are other siblings who love to get a share of the land.
Yeah.
and
That's right.
In fact, if the original owner gets 10%, he's lucky.
Yes.
He's invited for a dinner that you don't return. so given that, what you're proposing is that if the son goes and says, listen, I send this hundreds and thousands of dollars to you, please put this into your trust for my benefit. I don't want to go to court. I don't want to go to litigation. This, even if you pay 5%, will be worth it. This is the truth.
Yes. Now, what happens that your objective, one would like to achieve. However, what happens that whenever you create a revocable trust, and if parents have 3 siblings, 3 children, the situation is that one person is in USA, one son is here, another son and daughter is there in India. Those 2 people can convince the parents that you have power to revoke the trust, please ensure that transfer this, remove this particular beneficiary. US person is so well off, he doesn't need money, we need money. And yes, yes, that's what is the situation, you see, that's what is the situation.
From the title purpose.
No.
Agricultural land supposed to be owned by the farmer.
Yes. So in case of agricultural land, a non-resident cannot acquire agricultural land in India either directly or indirectly through the trust. That is prohibited. That is.
It's residence.
Uh-huh.
My parents has land.
Yeah,
there,
yeah.
And my father is a farmer.
Yeah.
And if he wants to transfer that land into the trust, then
Yeah.
can he do it? Agriculture
Yeah,
land?
that he can do.
Commercial.
Not only that he can transfer it to trust, but he can also put in will or trust. And as a non-resident, you will able to inherit and land shall be transferred in your name and you will become agriculturalist. Yeah. That is permissible.
But not by will, by for any other kind of trust. Will he be beneficiary? Yeah.
Yes, yes. That's, either way. Will, yes. Trust also, yes. There is no problem, you know. So, which I have dealt in the subsequent slide. But yes, it's correct. Okay. Distribution on demise is most convenient. A trust can be distributed very quickly within few weeks. And in case of will, it takes 2 to 3 years. Extension for future generation. In case of a trust, you can have for this generation, next generation. Under will also, you can create trust and you can extend it to subsequent generation. Now, any question on this, or I'll go to this joint holding of assets because this is also a complex issue in India. Yeah, yes.
Is there a limit that the Indian person can transfer the assets to a foreign trust? Let's say I have a US trust. Can the Indian person transfer the assets to that trust or not?
A person in India who is a resident in India, he is permitted to remit $250,000 every year. This is number one. Okay. To his relative, that's what they say, and that to close relative. Now, the provisions of the law are that you are permitted to remit money up to $250,000. You can invest somewhere, you can buy property if you want, all these things can be done. But when it comes to the process of gifting to someone, then they say that bankers say that let it be relative, you establish that the person is a relative of yours, etc. You know, so that is how there will be some limitations. You see?
My dad is in India, right?
Yes.
I'm here. I create a trust here, and here I'm a beneficiary. My siblings are beneficiaries, and my dad put the property in that trust. Let's say like 50 million, whatever, 10 million. Can we do it or not?
So the question is, someone is holding property in India. He wants to put it in the US trust. This is not permissible. So somebody is holding immovable property, real property or securities, etc. in India. He says that I want to put it in the trust in US. It is not permissible. Just I will give you a logic. The logic is that Indian government is monitoring investment in property as well as securities of Indian assets worldwide. So there are rules and regulations permitting or not permitting of transfer of securities and real property to a third party by a non-resident. So if you set up and transfer these assets in a trust, which is US trust, you will follow the rules and regulations of US trust, and you may change the trustees, you may change the beneficiaries, and the government of India will escape its monitoring. And that's the logic behind this, you know. So for me also, I will prefer if this is possible to do, but I can understand the logic and I appreciate that I need not try to work much on it, you know. Right.
The Bank of India will have it. The Bank of India, first of all, will have it.
Yeah.
You are putting a Indian property in a foreign bank, a foreign trust.
Yes, yeah, that's right. So they will not permit.
trust will sell the asset. It's sold to India, so they have to pay capital gain tax there.
Still, RBI wants permission for everything.
Yeah. So it escapes the monitoring of assets in India, and that logic is sound, Okay. So the next that people face issues or problem is joint holding of assets. When an asset is held jointly in India by A and B, and 50% is the share, if A, on demise of A, whether B becomes the owner of that property or not. If it is jointly held, generally it is presumed that it is a joint property, and on demise of A, B does not become sole owner of the asset. And such assets can be of securities or real property. It is possible that the government, the company which will receive the death certificate of A and transfer the shares in the name of B, it may permit the company or the B to sell the shares, realize the money. So it is possible for him, the other person, to deal with the securities, to deal with the banking accounts also. And in case of real property also, if it is jointly held, I have seen in India that cooperative society, if there are two members, one person dies, the other person goes with the death certificate, and cooperative society says, okay, we will remove his name and now you are the sole owner. Now, this is not legally correct. Not legally correct in all the three cases. But in case of bank account and securities, there is a law accepting this, that you do this, permit this. However, if B sells the asset, B does not become owner of entire amount. The legal heirs of A can follow with the B, can file a suit against them. Even sometimes legal heirs of B can communicate to the bank or communicate to the company or even communicate to the society that we are the legal heirs. He is not the single owner. We communicate to you, don't transfer this property, and that may help you to protect your interest. However, going forward, there is going to be a lot of litigation to recover the assets by the legal heirs of A. Okay, any question on this? Okay, so sometimes you make a nominee that A and B are there, and not you are singly holding or jointly holding. There is a nominee in favor of some person. So a nominee also does not become owner of the property. A nominee is merely a trustee of the asset of the person who has nominated him, and accordingly, nominee can deal with the asset. However, he'll have to account it to the legal heirs of the person who has nominated him. Generally, people try to nominate, say, property is there, he wants to transfer it to his son. He will put a will also that my property will go to my son. He will also nominate him in society or companies, and accordingly it becomes easier that he has a will also and property is transferred as a nominee also. So he becomes the owner and there are less issues. But in any case, if that will is challenged, then the other legal heirs can always challenge the ownership of the person who is a nominee. Yeah.
If there is no will, the person dies intestate, then what? If there is no will,
yeah.
The person dies
yeah.
intestate, and there are, say, 3 or 4 benefits.
Yes, yes. No, if a person dies without a will, intestate, right, then what happens that, as I explained to you, that you have to go to the court of law, apply for probate or succession certificate or letter of administration. Once that order comes, then the money will be distributed among legal heirs. Yeah.
The nominee, the U.S. nominee, does he have to report it on FBAR?
So my approach has always been that a nominee is equivalent to the beneficiary, and you have no legal rights to the money, then there's no reporting. What I typically see is people will put a parent or a kid as a joint owner to help facilitate dealing with the bank while the parents are alive, and that's where you have FBAR reporting issues. I typically don't report I'm not saying it's right or not, but I think we don't report a nominee as an owner because, or an export. Well, to me, on an FR issue is when the nominee walks into the bank and performing action on the account. And generally, my understanding is no.
Yeah. So, proceed.
It's 8:15.
It's
Already over. So let's try to wrap up in the next maybe 10 minutes. And
okay.
After we, please,
sure.
I understand.
I will quickly run through remaining slides. Whatever is relevant, I will take it up. Okay. So, non-residents and all are permitted to acquire property in India, whether it is commercial or residential. However, you are not required to allowed to acquire property which is in the nature of land, agricultural land. There is some question which I am asked many times that there are two non-residents here. There are two persons in US. Property is in India. They ask me, can they sell it directly and complete the transaction in US, make the payment and transfer the property? This is not permissible. There is no question of direct transfer of property between two non-residents. Okay. Another thing which I've seen that you face the issue of registration of property in India. So power of attorney is something which is a challenge. You need to go to consulate here in US and authorize someone. Then again, someone will go to India, register it and do it. So one may keep in mind that whenever you visit India, you may try to give limited power of attorney for the purpose of transfer or registration of property to a third party on the basis of your authority given to them. This may be good. Otherwise, you may have to go through the consulate route and remit it, transfer the property. Okay. Next is capital gains in India. Property capital gains long-term and short-term. Long-term is for a period which is held for more than 2 years or 3 years. The tax rates I already shared with you. And as far as rental income from property is concerned, you are taxed at a lower rate because if your income is 100 rupee, you are ad hoc given deduction of 30 rupees. So you pay tax on 70 rupees only. And this standard exemption is given to you just to encourage investment in property. So your tax rate on rental income is lesser than 36%. However, in India, this is the issue which you may face, if you are holding more than one property and that property remains vacant, then there is a notional rent as if that you have rented the property and you are liable to pay tax. Maybe some people may receive notice from tax department, some people don't receive, but let's proceed further. Anyone who receives, yes, law is that you may be taxed. You are liable to pay tax on notional rent also for a vacant property. Yeah.
It's very unfair.
It's unfair, but what to do? At the same time, I just share with you, there is a provision in Income Tax Act that if property is vacant, then you are not to be charged any income on a notional basis. You see, but they say that it should be vacant only for part of the year, not for the entire year. That kind of interpretation tax department does. So
the property is used only for a few days, like a couple of weeks in a year,
yeah,
to go and visit.
Yeah.
Is that considered vacant property or
no, say what happens that you have one property, it is totally exempt from taxation. Okay. But if you have more than one property, then you can't take a stand that I use this exemption. That's the reason. Okay, so now this is tax credit. I believe that we have discussed about the tax credit. I need not take, only thing we know that whatever tax paid in India, the credit that you get is for nil amount or lower amount, and you are required to pay higher tax.
Very quickly, if I have the 100,000 on our income in India, I get the federal tax credit since India does not have state tax waiver. With the New Jersey,
doesn't have full tax credit.
But you screw, you have to pay the tax on 100,000.
Yeah. Okay. So what I say, on the basis of this slide, I want to close 3, 4, 5 slides subsequently in a minute. in India, capital gain tax is lower. So in case of real property, one would like to ensure that you hold it for a long-term period, that is 2 or 3 years, and you reduce your taxation. That is one possibility. However, there is a challenge that if you reduce your taxation in India, what happens about US taxation? A US person will have to pay tax in US. So saving tax in India in respect of capital gain on real property may not be worth it, and it may not help you much to save overall taxes, So for this purpose, one should never go into litigation with the tax department for the purpose of long-term reduction in long-term capital gains in India. So I'm not dealing with this 2 slides. There are, let us see the next one, Now, this is cost of acquisition in case of assets inherited or gifted. In India, if it is gifted or inherited, cost of acquisition of the original person, the person who was holding, is to be taken, and it will be increased by inflation adjustment. However, in USA, on inheritance, there is a step-up cost, and as far as gift is concerned, cost of acquisition of the donor is there. This also I would like to skip. These 2 slides I would like to deal. You deal with the property purchase and sale. What I find is that whenever you buy or sell the property, the normal route of the transaction is that a non-resident seller enters into MOU, receives the deposit from the purchaser. Subsequently, what happens? The issues, having entered into MOU, transaction is through. However, it needs to be completed. The purchaser may say that I don't have a balance consideration, I'll take 1, 2, 3, 6 months. Second, awaiting for bank loan, which is delayed or rejected, or not completing the documentation. So the non-resident who is a seller, he will await, he may visit many times. So he has no legal route to cancel the sale document, sell the property to third party, return the deposit, or no other option. So it is important that when you sell or purchase the property, you need to follow a transaction process which is explained here. First, you finalize oral understanding of transaction and pricing with the purchaser or seller. Don't accept or enter into any memorandum of understanding for the transaction. Tell him that you finalize what are the withholding taxes that is required to be completed, so that he will bring or you will bring tax certificate from the tax office. So no issue as to taxation. Finalize the draft agreement. Tell the lawyer to examine the documents and see that if you are a purchaser or seller or the other party, ensure that all the documents, etc., are in place. Having done that, now everything is ready. You have not taken or accepted any deposit or given anything. You tell him that now I am coming to India. I will execute the agreement, and either I will pay you or you pay me the entire amount. I have not taken any money from you. In such a case, what happens that if there is a genuine buyer who is really interested, he needs to depend on your oral commitment that now this is our transaction, let us organize everything. In such a case, it is possible for a professional to assist you to complete the transaction of sale within 3 to 5 working days, because all the documents are completed in advance and there is nothing pending. So if the buyer or seller is ready, he comes there, completes the transaction, and you come back. Others I've seen you visit few times, you take months to complete or close the deal. Okay, so this is okay. So now I go to the next, repatriation of assets and income. Vinay, what do we do? Okay, this also I run through very quickly. As you know, up to $1 million you are eligible for repatriation, but this $1 million limit is not applicable on current income. That means if you are earning dividend or rentals of $5 million, $10 million, you are eligible to repatriate entire amount. Capital gain does not mean the income. It is the capital gain. So it will be covered under $1 million. If you purchase the property India in foreign exchange, then you are eligible to repatriate equivalent amount, and the balance sale proceeds will be covered under the limit of $1 million. This is how it is given. However, there is a special provision under Foreign Exchange Management Act that if anyone who has larger amount for repatriation, they will consider your application to give you remittance for 3 million, 5 million. And I've obtained quite a few permissions for amounts beyond $1 million, because many times people come, I'm selling property in $6 million. I cannot wait for 6 years, that way. So yes, generally Reserve Bank is liberal and they do consider the situation of case, Yeah. Any question? Okay. I think a lot of time, yeah. So it's better that, yeah, that's right. So with this, thank you so much. Right.
What are the other requirements for the NRI? There's so many people ask this question. So if you can just quickly say that.
I will run through. As far as banking accounts are concerned, you ensure that you comply with the provisions of bankers wherever you are banking with. And lots of changes have taken place, and now and then they will say that we will not allow you to operate your accounts, etc. But this is the situation. One is the banking account. Second is the securities transaction also. Many times people have their shares in physical form, and you need to change it over to demat and then sell it. You may lose substantial amount of appreciation if you don't complete this transaction.
But isn't the NRI not even supposed to have the other?
No, as far as Aadhaar card is concerned, you are not required or you are not eligible to take Aadhaar card.
That's required, not eligible. So many people travel to India just to get the Aadhaar card.
But that is wrong.
Because they are instructed from the other people.
From whom?
From India, bankers and banks.
No, that is a wrong guidance. That is a wrong guidance. For some time, 6 months, 8 months, government issued Aadhaar card to non-residents. But now what non-residents do? They'll go to India, give a local address. They will say, we are resident in India. Please issue us an Aadhaar card. That's how the Aadhaar card is obtained, which is illegal, which is not correct. Yeah.
Can they surrender their Aadhaar card?
Yes, yeah. Then they will question you. That how did you acquire? You represented, but do it. That's fine. No issue. Yeah, Vinay.
You've been very modest about talking about, talk for a minute about what your firm does to help our clients who are in the US who have properties in India. What do you do to help them?
Yeah. So, okay. As far as attending our clients are concerned, as a professional, I thought that there has to be good services available to non-resident Indians. And what I did was that any of your requirements, banking account, property requirement, investment requirements, any of your requirement need to be completed from your residence wherever you are located, say in US. You need not come to India. It's possible to serve you in its entirety on internet. We can send you the documentation. We can assist you to organize everything before you come. And if you are required to visit, you can finish it in 1 or 2 days so that you save your time and efforts. And many times I've seen that people receive notices which are not appropriate from tax department, and we assist them to ensure that this is properly taken care of. And one of the lady from Houston, she inherited shares worth 25 crores, which was purchased by her, the person, intestate person who died in 1956. Probate was obtained in 2011. Her share of asset was 25 crore, but other legal heir share was 100 crores. So around 125 crores, that means about 18-19 million dollars of funds were received by them after so many years. And I got them permission to repatriate. She told me that I am 90-year-old and I have 19 legal heirs. So if I die, how this 25 crores or $4 million will be collected by my legal heirs, and I don't know. So within 3 months, I obtained permission for her from Reserve Bank of India. And believe me, Reserve Bank of India is a good organization. I had not to visit also, just the proper communication, interaction, and speak over telephone. And you can get this kind of response from Reserve Bank. Even tax department is changing. I will say that I never agree to give any bribe to tax officers. I say no, we will not give. I'll come, my office people will come 2-3 times, but we'll attend more efficiently. There is no question of giving bribe, this is the way we practice. Yeah, and we are able to do better job, please believe me. Yeah, thank you.
I have one. But before you leave, please make a copy of the evaluation to Divya or Oksana, so you can keep the credit.
Yeah.
And Kirit and they are not going anywhere, so feel free to stay and ask questions.
All right. Okay.
One comment.
Yes, go ahead.
I don't know Kirit.
Yeah.
I, in fact, met his daughter for the first time 3 months ago. I live in the United States, but I have a lot of these issues, properties, securities, etc. over there. I have to tell you guys, whoever has interacted with that firm before, they are the most amazing firm.
Thank you so much. Thank you.
I have the same experience, by the way. They are the best.
Thank you so much. Yeah. All right. Thank you so much. It was great pleasure interacting with you. Yeah. Thank you so much. Huh? अच्छा, so busy, is very busy. Germany, India, in US का check नहीं cover नहीं. Yeah, okay, sorry. Okay, present. Thank you. Yeah, follow. Yeah, yeah, that's. What shall you? Okay, sure.
Do you act as a trustee also, or no?
Pardon?
On the trust, do you act as a trustee as well, or no? Or do you act as a trustee?
I am as a trustee, but it's fine. We can add. But generally, what happens? We say that go to a banker. We know the bankers. If bankers are reasonable and the cost is relative to the asset that you have, we recommend bankers. And those bankers, other way around, if they are attending some trust independently of our clients, they will come to us like, okay, you attend the tax work of our trust. Thanks for that.
Reason why, whenever we get requests, the most common question is, do you trust this person, especially if it's someone referred to you? That's the most common thing, and I won't give a recommendation unless I have personal.
That's right. So
that's why I said prefer.
Believe me, whatever my experience of last 25 years giving you knowledge, the way you have lost money, phenomenal. And it was fortunate that I succeeded. But proper care was not taken, or there were unscrupulous people around you, and you lost money. The way people lost money, the way we see your experience, it's not good. That's how, whatever I explained you today, we have a lot of on our websites also. And anyone who contacts, we attended very efficiently. Friday afternoon. Yes.
I have a question. In one of the slides you mentioned that if someone is holding the shares for the past 10, 15, 20 years, from January to August 2018, up to that point, there were no tax on the appreciation of the market value. But from this point onwards, they have to pay tax on the fair market value, right?
Appreciation beyond 30%.
2018. What if it's owned by the non-resident of India? Same applies. So until now, there was no such requirement. It just started. This is the new
It was totally accepted. Okay. Now it is.
So they will have to do that additional.
You have a lot of patience. Really appreciate it. And this was wonderful.
Yeah, thank you so much.
The shares are purchased in again, it is not receiving. This knows
knowledge and patience.
By the share, it was board like as a
non-resident. Yeah. Why is it non-resident? Shares are in India, companies are in India, Citus is in India.
It's a non-resident issue, right? Foreign.
So it is easy for you. You want it as a non-resident.
Yeah,
You
I
paid
bought like
out
25
of-
years ago.
right? And you paid in rupees or you paid in dollars. If you paid in dollar terms, then you are eligible to repatriate entire amount, whatever sale proceeds.
If you stay,
And otherwise, there are no rules, regulations. You can hold it, you can sell it, you can create a trust.
Indian Modi government making from real property, some are registered, but in your paid for it. May not be property. હવે કે છે કે મે 2019 general election પછી they will bring this mechanism on. We can only come there for a limited time. How do we prove an amount of parents allow me to? How do I prove how they paid for it and how we got the property?
So your parents are holding the property.
No. They were holding. They are no more.
They were holding. They are no more. That's fine. You not sure that how you acquire or how they acquire.
Because that's what the speculation was. We received quite a few emails from India saying this is a speculation that they are going to create a special mechanism and you are going to register your property as well as prove how was the property paid for.
You shall be an exception in what you do. That such cases will be exception. It is for others. Like
Where they are holding more properties.
Yeah. Or you cannot establish that this was ever held by your parents. And you say now you register it in my name, then what will happen? Okay. Thank you. So
brilliant, brilliant. Knowledge, really,
I will give a lot of credit. Yeah. That's right. In fact, ચારેક લાખ રૂપિયા યુપીઆઈ પડ્યા છે મારે 15 દિવસ પહેલા કીધું મહિના પહેલા કીધું પેમેન્ટ કરાવી થઈ જશે બેટા થેન્ક યુ
Give me a call.
I see. Oh, wonderful. Okay. Oh, nice. That's nice.
I never met you when I came to India. That's let me just make you here.
Good. I'm so happy. You know him. I know him since 71.
71.
No, because I know his brother and his father. In fact, his father was partner in this firm, shipping company. That's right. So we kept him so much in high regard, Yeah, that's right.
He started. We used to do. We were doing articles. He was senior to me, maybe a couple of years, right? Then Atul was there. Nimish became a partner. Then I don't know what happened to
He took over the stock.
The stock exchange.
In 95, I said I'd continue in this, Maybe it's once luck, what you say. The stock market also is done well.
But I think you have very good help. Whatever people I dealt with, I think they are very good.
They are very trained.
I like what you say.
Hello.
Hi, I just want to express what is this Russian lady I've been to India a few times. I work for Morgan Stanley, but actually do have a very close friend.
I see.
He and I ran a business. I know a lot of part of it, but I traveled a lot in India. I've actually been in your neck of the woods.
Wonderful.
So now, may I have a card? I know it's on the, believe it or not, we need good help in India. The tax, the foreign goods and services, what it is, TG.
GST.
GST is a problem.
Ah,
Because all the US, it's basically Indian government encourages to buy Indian. Is that the idea of that tax? So,
how come GST is problem for you? Are you giving
I'm sorry, who is
services?
invoices? Yeah, when we provide services, they don't pay extra. It's a problem to the end user.
Yes.
That's the problem. They'll be disincentivized to buy from us, so they will buy through some Indian pass-through. Is that what people do these days?
I will say that if they buy from you and they further use your services for some their own business, then whatever they pay GST on your services, they will get taxed. You see, that is one. And I tell you, what has happened in GST, it was there earlier also. There was a reverse charge mechanism. You pay import duties, you pay VAT and value-added tax in India. Service tax.
Sorry to interrupt you, John.
No, that's okay. We are learning something. Welcome, right?
Fantastic.
So,
I'm a wealthy client. I work with individuals here in the US, but a lot of my clients naturally, I work for Citigroup. It's a big brand in India. A lot of my clients, because I'm Russian born, and so we're speaking with the other blonde lady in Roxana, quite coincidentally, I have no idea. So my thing for Renee, clients, the thing was, let's do international. Because there's some general themes for companies. So a lot of my clients are foreign, a lot of Indian clients. There's a client that married me. Well, I have to say, unfortunately, I had to hire a lawyer to collect from, but we figured it out. They have a business in South Carolina.
Oh, I see.
But, you know, and a lot of them come over here. And the principals need help. And I see tax advice from Renee. So
That's
a
right.
lot of, so my work has internationally.
I see. Very good. See, being at
So just
Morgan
give